Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Today I have another exciting naturalization case to get to. Before I do, quick reminder, this Thursday, November 12th at 9 p.m. Eastern Time, myself and my co-host, attorney Amanda Shapiro, will be having a live Q&A discussion on naturalization. Also on Monday, November 16th at 9 p.m. Eastern Time, myself and attorney Hashi Richards will be having an honest discussion on marriage and the immigration law. For both of these events, we have more information on the Facebook page. You can email us questions in advance, ask questions live. We encourage you to ask questions. And so make sure that you mark it on your calendar, like us and follow us and whatnot so you don't miss it. So the case today is for a client who is a native and former citizen of Greece. And this is a very complicated case. And I'll take it slow, but it's a very important case and teaches us some very important lessons. Our client first entered the US in 2001 with a B2 visitor visa. He married a US citizen in 2003, and then she filed for his conditional green card, which she received in 2004. In May of 2006, he and his wife jointly filed the I-751 petition to remove conditions on residence so he can get his 10-year green card. In November of 2006, his I-751 was approved and he received his 10-year green card. However, in June of 2006, which was before the I-751 was approved, but after it was filed, while our client was still living with his wife, she served him with a divorce summons. And actually, she really just served him with the affidavit of defendant, and he refused to sign it. But, you know, in New York and most other states, you don't need to even consent to a divorce. Only one party does. So in August of 2006, his divorce was final. Now, he never told USCIS that he got divorced, and then they approved his M400. And that was his first mistake. He should have told them right away and switched to a waiver of the joint filing requirement based on a divorce that was, a marriage that was entered into in good faith, but ended through divorce. So it turned out that his wife had somebody forge his signature on the affidavit of defendant, and he had no idea. He never even got a judgment of divorce. He got nothing. But then he moved on with his life. In 2010, he filed for naturalization. And at the interview, the officer says that there was something wrong with his application and that he was ineligible. And my client had no idea what he was talking about. A week later, the officer called him and said, "I need you to bring all of your divorce documents." So he went to the court, got the divorce paperwork, and brought it in. And when he brought it in, he sat down with the officer, and the officer said, "So it says on this affidavit of plaintiff," the plaintiff was his wife or ex-wife, and it also said in the findings of facts and conclusion of law that my client and his wife or ex-wife had separated 3 weeks after their marriage, so back in 2003. And my client was like literally in shock, like, what? I was living with her until she served me with the divorce paper. Like, that's not true. And then it also said he, not just that they were separated since 2003, but he abandoned her just 3 weeks after the marriage, which, you know, he then had his green card interview and then the I-751 was filed. So that's a big problem. So he brought it to them, but they still denied it based on a lack of good moral character, claiming that he was untruthful about the dates of his marriage. And that's when our client first came to us. And when we saw everything, we said, well, I don't think we can convince them that you weren't lying without amending the divorce, because it said 3 weeks. I mean, that's a big problem. If you're only married 3 weeks and you're telling USCIS you were married for, 3 years. So first thing we did was file a motion to vacate the divorce. And the judge, and this was in September of 2010, and we did it based on fraud, misrepresentation, and other misconduct. Now, our client's ex-wife actually claimed that she didn't even tell her attorney at the time about when the date of separation was. He actually just put it in himself. So there was that claim in the motion to vacate the divorce as well. The judge actually didn't vacate the divorce, but ended up in December of 2010 amending the divorce And the amended divorce actually included a lot of amendments. It changed the affidavit of plaintiff to say the right separation date. It changed the wife's address on the divorce because she claimed she was living at her father's address when they were actually living together. It changed the date of separation. It took away the ground of divorce that our client abandoned her, and it was changed to constructive abandonment, which is withholding of sexual relations. They didn't have sexual relations in a long time. So it's like it's similar to a no fault. It wasn't going to hurt our client in this case. So we finally got that taken care of, but by the time the divorce was all fixed and ready to file for the I-751 divorce waiver, my client was already in removal proceedings. Back then, when he was in removal proceedings, we had something called administrative closure. And that might come back now that Biden won, who knows. But essentially, if anyone out there watching has been in removal proceedings and you were recently put on the status docket, it's kind of similar. The status docket, you do have like a potential future hearing date, unless something happens before them and you notify the court. With an admin closure, you don't have a future hearing date. And either side, the government or you, can ask the court to recalendar your case. So you could either, the government's like, okay, now we can deport this person, or you're like, now I have relief from removal. So it was very common back then when you had an application pending, so like an I-755, which you first have to file with USCIS, and if it's denied and you're placed in removal proceedings, you then can renew your application and basically get a second shot with the immigration judge. But if you filed jointly first and then you switch to a waiver ground, no matter what the waiver ground is, that is a brand new filing. So my client had to first file it again with USCIS, and if it got denied, he would have gone before the judge. So whenever USCIS were waiting for them to make a decision, back then, this was I think 2013, the immigration judge would administratively close the case, and that's what happened here. So my client refiled his I-751 as a marriage that was entered into in good faith and terminated through divorce with his nice amended divorce. That was approved. We then filed a motion to terminate removal proceedings. When that was approved, we filed his naturalization application, and that was finally approved. So it was quite a long journey for this client and quite some shock. I've had other notable approvals about people who thought they were divorced but really weren't divorced. People, especially when they're doing an uncontested divorce, they don't always pay attention to it, but it is incredibly important. You know what's in all those documents, whether you're filing it or your ex is, and you do have a right to see all of those documents. And the other really important thing is if my client had notified USCIS right away when the divorce was filed, they may have believed him a little bit more when they saw the date of separation, that was the incorrect date of separation. Because you are actually required, when you get your green card through marriage, and if you're no longer with the person who filed for you, you're actually supposed to tell USCIS, because you only have a green card because your spouse or significant other requested it from the government. So if you guys aren't together anymore, the law technically says you shouldn't be here anymore. So it gets very complicated, but it really comes just down to honesty. We tell people that all the time. Our client was being honest. He had no idea. He didn't even get served the judgment of divorce to know it was final. So yeah, it's a very good case that has a lot of different interesting aspects. And we will have another case on that. Say hi, Aaron.
Hi, Aaron.
I like your mask.
Thank you.
We'll have another notable approval on naturalization tomorrow. And then on Thursday, this Thursday, November 12th, 9 p.m., our Q&A discussion on naturalization. Send us your questions in advance, ask us live. And then Monday, November 16th at 9 p.m. Eastern Time, myself, attorney Hashi Richards, we will be talking about marriage and the immigration law. So like us, follow us on Facebook and YouTube and Twitter and whatever else we're on so that you don't miss anything. Have a great night. We will see you tomorrow.